This is, for anyone who's joining for the first time, our quarterly webinar on key issues for employers, range of employment law topics. I'm Robert Maddox, I'm in the employment law team, and today I'm delighted to be joined by Monica Sobieski, partner from our media and information team. Monica joined the firm to lead our data protection and cybersecurity service. So absolutely perfectly placed to take this talk focusing on data protection, data privacy. She has a wealth of experience in all aspects of data and information law, advising employers as well on those issues. And today's session will be based on UK data privacy law, including the UK General Data Protection Regulation, which we'll all know as the UK GDPR, and the Data Protection Act, which again will all be familiar to us as the DPA 2018. And we'll be answering questions today surrounding employer obligations in relation to data subject access requests and GDPR rights requests. So I know as an employment practitioner, this is something that we deal with varying degrees of regularity, always something important that we understand, and how to make the process smoother and less difficult and intimidating and all those words. And Monica's certainly going to be helping with that today. So enough from me, pass you over to Monica for today's talk.
Thanks, Rob. So hello, everyone. You're about to see two quick polls pop up. They're completely anonymous and confidential to this session. I'm grateful if you could have a look at those. They're just about how you're experiencing and dealing with data subject access requests in your organization. So if we could have the first poll pop up now. Has your organization developed an internal data subject rights requests policy? So yes, we have one in place and we rely on it regularly. Yes, but we don't actually really use it on a day-to-day basis. No, but we're in the process of developing one. No, but we intend to develop one in future. Or no, and we don't have any plans to develop one. So if you would like to answer now, and we'll just give that another 20 seconds. Thanks. If we could have the results now. Oh, very interesting. So clearly the session is going to be right up your street, because we will be talking about the sort of things that you might consider putting in your policy. So 57% don't have one yet in place, 36% have one, but don't really use it. So perhaps we could help with making that a bit more user-friendly through this session. Could we have the second poll, please? Does your organization use any specific software for managing data subject access requests? So you can tick multiple choices here. Yes, we use a DSAR request management system, for example, OneTrust sort of case management system or similar. Yes, we use a sort of basic ticketing system or request form, e.g. on Google Forms or similar. Yes, we use an e-disclosure platform for reviewing the disclosure and redacting it, something like Autonomy, Luminance, something similar. Yes, we use another type of software, or no, we handle all our data subject access requests without the use of specific software. So another few seconds for you to respond to that one. Fantastic. So if we could have the results of that now. Oh, very interesting. So potentially you're dealing with these requests without the help of any specific software. It's quite a manual process, perhaps quite slow and time-consuming process. Yes, again, some of the tips in this session might be very helpful, but again, you may want to look in future at whether there's other ways you can make dealing with these DSARs a little bit easier for your organization. Right, so I'm going to share some slides now, and we will kick off the session. Hopefully, let me just move that across. You can all see those slides now. So today we're going to tackle the trickiest of data subject access requests, or DSARs, or SARs as they tend to be called. And those are DSARs involving employees. These are tricky even for DPOs and privacy professionals to deal with. Why is this? Well, I'd suggest that there's 3 reasons. Firstly, there's the volume of data that you might hold on employees. They might have been employed for 3, 5, 8, 22 years, and frequently you'll get requests for large chunks of that record. We'll talk about how to deal with that, but volume is almost certainly a challenge. Complexity, so not just the scope of what's being requested, but also applying the various exemptions that may apply in that context. And finally, background and context. So often these subject access requests tend to come up in the context of a redundancy exercise or a disciplinary or tribunal litigation. So the situation is already fraught without having a data subject access request to deal with on top of that. In terms of what we're going to look at today, first we're going to touch on other common data subject rights requests that could probably merit a whole separate session under the UK GDPR. Then we're going to look at the very first steps you take when you receive a request. What do you do when you receive it? How much time do you have to respond? Can you ever refuse to comply? We'll then turn to look at searches, assuming that you're going to proceed with dealing with this request. What is a reasonable and proportionate search? We'll look also at the response letter that you have to put together, and also how to handle the disclosure, how to redact it, and how to send it across to the data subject. Finally, we might touch on some challenges, i.e. what happens if it all goes wrong. So data subject access requests are just one part of a wider framework of requests that can be made under the GDPR. They're our main focus today because they are by far the most frequently used right under the GDPR. They also existed under the old law, so they've got quite a history to them. However, there are some other commonly encountered data subject rights requests. I've put these two on this slide, which I now encounter quite frequently. The first is the right to erasure, otherwise more commonly known as the right to be forgotten. I see these requests now actually surprisingly frequently. And they might occur when, for example, an employee is unhappy with a particular record, such as a performance review, and they're trying to seek to erase it. Individuals trying to control the flow of information in a particular process, like a grievance process or disciplinary, or alternatively, individuals enforcing their retention period. So an ex-employee that really wants to make sure you've deleted their entire record because they've had an unhappy history with you. Very important note, there's actually quite limited circumstances in which the right to be forgotten can be validly exercised, and there's a number of exemptions as well. So it's not the case that simply because someone's made a request, it will be granted, unlike the data subject access request right, which doesn't require any particular circumstances or preconditions. And actually, right to be forgotten could be a whole session in and of itself. So we might revisit that in future. The right to rectification, this is used to correct genuine mistakes, the wrong date of birth, the wrong medical history, or again, sometimes it's used in contentious situations to try and control information flows. I've seen it exercised in an attempt to put the record straight, as the individual put it, and so they want to put their supplementary statement in to say, this record says X, but actually I want to put a statement in to say this isn't the full picture. Actually, there's all of this other context that I want to be recorded against my record. So that's where you might encounter it. So as I said, commonly encountered data subject rights requests. Less commonly encountered data subject rights requests. So there's the right to restriction and objection. These tend to sort of go together. They're not as popular as the right to be forgotten or data subject access requests, but I have seen attempts to use them. They're more intended actually on objecting to direct marketing or profiling. Restriction more intended to restrict the processing of data while it's corrected. But I have seen this used in contentious scenarios, as I said, attempts to control information flows. And again, there's limited circumstances in which they can be exercised, like the right to be forgotten. The right to data portability and the right to object to automated decision making, I would say these are quite rare. Portability, in theory, it could arise with individuals moving data to a new employer, but I've not seen it actually exercised in that way. I've seen it exercised in other contexts. Automated decision making might be an area which comes more to the fore in future. This doesn't apply where there's some meaningful human decision making involved, but could apply where, for example, algorithms have determined an individual's bonus or their suitability for promotion, or even if they're used at the stage of recruitment. So you may encounter that, but again, it's very rare. It's actually not as well known. It's become better known since the A-level algorithm challenge against the government last year, but it's still not really frequently used in the employment context. So moving on to first steps, even before we get there, what is a data subject access request? Well, a data subject access request, a valid one, can be made by any means, oral, written, social media. If you have a form, that's good practice, but it's not binding on the individual. You can't force them to use your form. So even if they make an oral request, it doesn't even have to state it's a data subject access request. If they're asking for their data, you should interpret it as such. There's no particular circumstances required for making the request. I've touched on this already. It's free at the point of request. So under the old law, you could charge your £10. You can't do that now, although the recent DCMS consultation paper that's come out for future changes to the UK GDPR has floated the idea of bringing back fees. I used to find the fee was something of a sifter. So individuals who are serious about the request would pay the fee quite quickly. Individuals who are not so serious wouldn't pay the fee, and then the whole thing would drop away. At the moment, it's absolutely free. You have to deal with everyone, but query whether fees will be brought back in future. And it covers any documents you hold electronically or manual records in a filing system. What's a filing system? Well, it's anything which is indexed and navigable. So an HR file, a filing cabinet, a box that's labeled. It doesn't cover, an archive box with lots of papers thrown in together where you have no idea what's in the box. But again, quite difficult to argue it's not part of a filing system in my experience. So that's just one for you to bear in mind. A DSAR is not. a set of questions which you're required to create some new information, some new data to answer. So some individuals confuse a DSAR with an FOI request or something similar, and they start asking you questions requiring you to create new data. You're not required to create new data. It's a right to their existing data. It's not a request actually for pre-action disclosure of underlying documents, although it is used in and around litigation. It only entitles you to a copy of data, not the underlying documents, and this is a very important point. It's also not a request for somebody else's data unless the individual has authority to make the request for a third party. And sorry, just moving that back so that you can, we will just look back at the three elements of the data subject access right. So it entitles you to three things. Firstly, confirmation that data is being processed. Is it or isn't it being processed by you, the employer, the data controller? Certain information about the processing, and finally a copy of the data but not the underlying documents. So in terms of your first steps when you receive one, you will want to confirm identity if you're unsure. So this won't apply if it's a current employee, you know who they are and they've emailed you from their work email. But it might apply if, for example, you receive a request from an ex-employee, they've emailed you from an email you've never dealt with before, and it's reasonable to confirm their identity, then you should do so. And that's to prevent, of course, any data breaches. Confirm authority. So if a law firm or claims management firm has made the request, then you should make sure that they have authority to do so on behalf of the data subject. Check if any other data subject rights request has been made in tandem and respond to it. Best practice is to respond to them separately, just because, as we'll see, with employee data subject access requests, you'll tend to extend time in the employment context. Not always, but because they tend to be complex, whereas there might be a simple data subject rights request made at the same time, which should be responded to within the normal 1 month. Check the date the request has been made. It's actually the date when you receive it that counts for timing purposes, but make sure you check that so that you can set the clock. Check if the scope of the request is clear. If it's not clear, for example, someone's done the classic, I want absolutely everything you hold on me, and there's 22 years worth of stuff, it's reasonable for you to seek clarification. And the ICO has some interesting guidance about this, which we're just about to come on to. So you have 1 calendar month to respond. However, the ICOs impose a sort of next working day rule. So if one comes in today, you have until the 16th of October to respond in normal circumstances. But if the 16th of October falls on a Sunday, you will be required to respond by the Monday, i.e. the next working day. Similarly, if it falls on a bank holiday. Stopping the clock. So I mentioned that if the scope of the request is not clear, the ICO has issued guidance to say you would stop the clock on the day that you seek clarification. So if you seek clarification on day 3 after you receive the request, the clock is stopped until you get the clarification you need, and then it's started again, and you would have 27 days to respond. If you're seeking ID or authority and you don't have that, the clock does not start until you receive the ID or the authority. So that's something that's important to bear in mind. You can also extend time by 2 further months if the request is complex or there are numerous requests. So frequently in the employment context, you may be extending time by a further month or a further 2 weeks or a further 2 months, depending on the request, simply because these are the most complex types of requests, and it's entirely specific to the context. You'd have to be able to justify the extension of time. So it's good practice to send an acknowledgement letter at this stage, and the acknowledgement letter should say you've received the request, including the date of receipt, seeking ID authority clarification where relevant, and if you can, i.e. you haven't stopped the clock, setting out the date you propose to respond by. And I would suggest that is good practice at this stage, and also prevents you from getting an irate email a week or two after you received the request saying, have you received the request? So head that off at the pass, and build up your paper trail by acknowledging the request and confirming when you'll respond by, and then work to that date. So can you refuse to comply with the request? Well, yes, but in very limited circumstances, where either the request is manifestly unfounded or excessive. What does manifestly unfounded mean? Well, for example, if the request is intended to harass your organization rather than a genuine request for data. So in a case I once dealt with, there was evidence on social media of various aggrieved, this was not in the employment context, aggrieved individuals who said, we're unhappy with how this organization has dealt with our complaints thus far. Let's bombard them with data subject access requests. They won't be able to cope. And then we can complain to the ICO and they'll find the organization. So in that sort of situation where you've got some evidence that actually they don't want their data, they literally just want to harass you, that is the sort of situation where you could say it's unfounded. Or there's no real intent to exercise the right of access. So for example, someone says, I'm going to make a data subject access request, but pay me 50 quid and I'll go away. That could be unfounded. Contrast, however, where there's ongoing litigation and they've made a request. Prima facie, that is a request you should deal with as a valid request, simply because an individual might be fishing for information because there's ongoing proceedings doesn't mean that you can refuse the request despite context. However, it's only a right to their data, so that if they're fishing for disclosure of full documents, they're not going to get it through this process. And you can explain that to them in your response letter. Excessive. So this is where, for example, you get repeated requests, or the request is clearly sort of unreasonable in its scope and taking into account your resources and other factors. I must say the threshold for both of these is very high, and you will have to you can charge a reasonable fee if you want to, but most people refuse to act on the request. And you will have to justify why you've refused a request, including setting out reasons, including the right to complain to the ICO, and you should send the refusal letter within 1 month. So don't wait 4 months and then send a refusal letter, respond within the normal time frame. The threshold is very high, and you should be rarely reaching for this, but there might be some situations where it is appropriate. Let's just skip forward to, we're now going to look at the searches. So how should we carry out our searches? We've got our ID, we've got our clarification, we know what we're looking for in theory. Well, the duty is limited to carrying out a reasonable and proportionate search. What does that mean? Well, it's what's reasonable and proportionate in the circumstances, taking into account any specific difficulties retrieving the data. We'll go on to some of these shortly, and the fundamental nature of the right. So the presumption is the individual has a right to their data, and so you should make serious efforts to look for that data. It's good practice to help you out to organize your information management systems beforehand. So having a self-service system where people can get their own pay slips or their performance records so that you can just point them to those in the response letter is helpful to you. You don't then have to go and fish around for this information yourself. The value of data mapping, so you know which closets the skeletons are buried in. It will help you determine which systems to search, and also so that you know when and how to exercise your retention periods to make sure you're clearing out data on a regular basis, and you don't have 22 years of records lying around. Finally, having a DSAR policy. So that's primarily for your own employees to be able to recognize and escalate requests, but also a good DSAR policy should contain a step-by-step guide for dealing with these requests. You can, if you wish, include some of the content of this presentation, and it may to some extent provide some guidance generally on the sorts of systems you would search, e.g. email systems, HR files, pension records, but that is not to say that it should predetermine completely what systems you search, and every individual request should be taken as it comes. Hopefully I should be able to get a little box up which gives some suggestions, on the scope of your searches. So I'd suggest that the way you structure these is to look at the custodians, like a disclosure exercise in litigation, the custodians, the time frame, and the systems. So the way you would set this out in the response letter and the way you would tackle it is to say, we're going to give you a copy of your paper HR file, a scan of the paper HR file, plus conduct searches across the email accounts of Mr. X, Miss Y, Z from the 1st of January to the 16th of September, because that's the relevant period. And even if the individual will not hasn't sort of set this out specifically, you can sometimes glean from the context of their request if they're asking about a particular period. That they'll often set it out like this themselves, but you can help them out by setting it out in this way in the response letter as well. So again, specific issues and problems. So the first is, how is data, how do you determine that personal data relates to the individual? Well, this is a tricky one, and actually the ICO has separate guidance on what is personal data. Sometimes it's obvious, for example, an opinion in an email about Robert Maddox, or conversely, it's obvious because you're looking through the disclosure and you found a set of very generic slides for a business presentation, and the data subject has just been named as part of the team preparing that, team of 20 preparing those slides. Well, whilst the person is named, the data itself does not relate to them. You don't have to send them a copy of the business slides. Clearly, it doesn't relate to them. However, it's very context specific. So there may be grey areas. Often emails that the individual is copied into is a sort of grey area. Emails organising a big drinks event which the individual is copied into, the data is probably not going to relate to them. But if that drinks event was the event at which the alleged sexual harassment occurred, then that email might be very relevant depending on the context. Bear in mind that there is some separate guidance on this, and it's a tricky question. What about personal and private devices? Well, in general, you're not required to search these unless either there's a sort of absolutely general practice of holding work data on private devices, which there really shouldn't be. You should have a policy which prevents that, or you're reasonably and you're reasonably certain the personal data you're looking for is on that device. But actually, there's a real fraught question here about if it's the individual's private device, then they're entitled in general to their own privacy, and so it will be a very rare occasion when you would be searching or asking to search an individual to search their own device to send you data. That's the way you deal with it. You'd ask them to search their device rather than go out and grab their personal device. Very rare circumstances, and ideally it should be restricted by your HR policies. What about information you've deleted? Well, if it's been put beyond use but would require forensic expert evidence to recover it, not required. to do that. What about archived information? Or you should put the same efforts you would do yourselves into retrieving some information you need to go through backup systems. But again, you're only required to do what's reasonable and proportionate. So moving on to briefly cover disclosure and exemptions. So you've got your chunk of data together now, and you need to go through it to redact contents out, to sift the information. So the first thing you'll be doing, which we've touched upon, is pulling out anything which just is irrelevant. It doesn't relate to the individual. Then you will be looking at third-party data. So this is a big one. You shouldn't be, in general, revealing the private information of third parties. This is, again, context specific. And if you can't seek consent from the individuals, then you have to determine what's reasonable in all the circumstances. So you may determine that it's reasonable in the circumstances to disclose unredacted the line manager's name because the individual know it's that person anyway. However, you may not disclose in emails that the individual hasn't seen random employee or random manager number 3 who just happens to be incidentally mentioned in those emails, and that is a determination which is tricky to make and is again context specific. Some organizations take the view that they'll just redact out all third-party data and only disclose the individual's data, not the context specific stuff. That's not technically correct, but it may be understandable, especially in a particularly contentious situation where an individual is raising lots of complaints and grievances. Legal professional privilege tends to arise. There are some tricky calls about this as well. 2 types of privilege: legal advice outside of litigation and litigation privilege. They operate in different ways. And I've been called on to make calls about redacting or removing what's legally privileged. There's a specific exemption that comes up in redundancy and other employment situations, which is around management forecasting. So if you've got an ongoing redundancy exercise and revealing the data during that exercise would cause prejudice to your business, then you're not obliged to release that data at that time. But that prejudice condition is there for you to rely upon the exemption. But bear that in mind because it does come up in contentious redundancy situations. Negotiations with the data subject, you're not obliged to disclose information if it would prejudice those negotiations, and confidential references, but only if those are, stated to be confidential and intended to be treated as confidential. So how would you supply disclosure to the data subject? Well, you do it in a commonly used electronic format and securely password protected, potentially encrypted. And you'd explain what you were doing with a response letter. I won't go through all of this in detail, but you'd essentially want to ideally set out the request, set out the searches you've conducted, confirm if you're processing the data, set out the required information, set out you've enclosed a copy of the data, and also set out in headline terms what exemptions you've relied upon. That's the sort of best practice response letter. And then finally, challenges. So in theory, if it all goes wrong, the individual complains to the ICO, but the ICO's normal approach at the moment is to then write back to you and say, could you check you've dealt with the request properly? And they'll only escalate it to an investigation if either there's a bunch of employees all making the same complaints about your organization, or if the individual's complained twice. So that's really their standard practice. They'll usually write to you and ask you just to mark your own homework. In theory, the ICO has a power to impose fines. We've all heard about the scary fines, and also the individual could apply for an order for disclosure and or compensation in theory, although it doesn't tend to get this far. Usually it will end up being a complaint to the ICO. and if it's particularly contentious, an investigation. So I'm going to pause there, and I think we have 5 minutes still for questions, if anyone has any questions. I'd be grateful actually if, given that I'm screen sharing, I'll see if I can see the Q&A. Oh, so no questions in the Q&A. Any questions in the chat? No questions in the chat. So I think probably at this stage, I could run through 1 or 2 scenarios, or I could answer any questions if anyone has any questions.
I think we have a question that's cropped up in the chat, Monica, if you want to take a look.
Brilliant. Okay. Can you reference WhatsApp, and is it covered? So I'm going to take that. That means does that mean that you'd be obliged to look through WhatsApp messages and private messages of the data subject? Well, this is you know, again, a kind of difficult and contentious issue that comes up. So if you're dealing with an individual who has a WhatsApp on their work phone, which is used for work purposes, then potentially you would be reviewing that material if it's requested. However, of course, as we all know, this goes into a very grey area quite quickly, because individuals, even with a work phone, start setting up private chats, including private chats with other employees. If it's there's a sort of definitely a situation where if it's their private WhatsApp on their private phone, obviously you're not going to search that. If it's their work WhatsApp on their work phone that they're using for work, you do search that. But on the other hand, if it's private chats on their work phone, potentially you wouldn't be obliged to search that. There was in fact a case some time ago called Barbulescu in Romania, which did involve looking at private messages in a work phone context, and in that case, from recollection, the employer was criticised for infringing the individual's privacy. So again, there isn't a sort of general rule that I can give you for this, but it's certainly the case that individuals using their work phones should be discouraged from, just like with the private devices issue, discouraged from setting up private channels of communication on their work phones, because if technically it's their work phone, and if it's being used for work, it may be searchable. But there is also a good argument for you to make, if you're being asked to search through them, that actually that would infringe the individual's, the third party's privacy, and so you shouldn't. It's a really, really tricky and context dependent issue, particularly if you know, as I said, that certain data is definitely on those private chats. If you're not sure, you certainly shouldn't be asking individuals to search through their private chats. I hope that helps, but I'm very happy to take that offline and get the whole context and background to that question.
Thanks, Monica. That yeah, very well covered on those sort of ever increasingly tricky areas of communication between employees in the private and employer spaces. I don't think we have any more questions in the Q&A or chat. So if you're keen to go through a case study, feel free, or
I think we're sort of at 1:15, so we're at time. I will just for people on the webinar just mention I do have 2 case studies in here, and rather than going through them in detail, I will say in scenario 1, we've got an individual asking for absolutely everything in the context of their redundancy exercise. You know, this is meant to prompt you to look at what's reasonable and proportionate, and suggest that if you want to, if you're worried this might go to the ICO, run some test searches just to show what huge volumes would have to be produced to give the individual absolutely everything. Actually, if he's asking about a redundancy exercise and that's really what he's exercised about, pardon the pun, then it may be defensible just to focus on disclosure around that redundancy exercise. Second scenario, this is a situation where you might be reaching for the manifestly unfounded and excessive reason to refuse a request. So particularly where the individual has made repeated requests in the same year. Again, it's rather context specific, but if the requests have overlapped, if the individual keeps asking for the same data, then you definitely want to consider being in that manifestly unfounded and excessive territory. Also, retention periods. If you've deleted something in your normal deletion cycles, you don't have to explain that you've deleted the data. That's the normal operation of your systems. Just provide what you have. So that's the 2 scenarios here, and I will stop sharing the slides. Fantastic. Well, right. Well, over to you, Rob, to close, and thank you everyone for joining today.
Thanks, Monica. Incredibly helpful step-by-step approach to dealing with these, and I do encourage people to take that sort of measured approach. Thanks also for name dropping me in there. Now, we learned today that I wouldn't necessarily be entitled to access the seminar under a DSAR, but thankfully I won't have to, because we'll be circulating the recording by email so that people can catch up and have a look back at any particular points. Bit of a data privacy joke in there, who said it was impossible. What we will also be doing is condensing elements of this into a blog so that people can access it in perhaps a more convenient way when they're dealing with these processes. And obviously, you'll have Monica and my email addresses, and you'll be able to contact both of us. Feel free to drop us a line and we'll be able to address any particular issues that you have and talk that through. Thanks again for joining us. We will be running another one shortly. As I said at the start of the webinar, please do complete the feedback form, and if you want to suggest any topics, really helpful. This one has been very well attended, so I know that this is an area that's of interest to a lot of people. If there are any others, let us know and we will cover it. But enough from me. Thanks again to Monica. Thanks to you all for joining, and we'll see you next time. Thanks.